Thanks, everyone, for joining us this afternoon for this panel on history, tradition, and the religion clauses. I'm Micah Schwartzman at the University of Virginia School of Law, and I'll be moderating our panel. We have three distinguished scholars with us. I'm going to briefly introduce them. You can find longer profiles of them on the conference website. First, we have Tom Berg, who is the James L. Oberstar Professor of Law and Public Policy at the University of St. Thomas School of Law. Next is Kathleen Brady, who is a Senior Fellow and a McDonald Distinguished Fellow with the Center for the Study of Law and Religion at Emory University. And third, Stephen Smith is the Warren Distinguished Professor of Law and Co-Executive Director of both the Institute for Law and Religion and the Institute for Law and Philosophy at the University of San Diego. Each of our speakers will have 15 minutes to present, and then we're planning to have about 30 minutes for questions. And with that, I am going to turn things over to Professor Berg to get us started. Thanks.
Thanks, Micah. Adding my thanks to the organizers for a great conference. So I'm going to talk, in the first part of what I say is going to be a bit of a review of my book here. I'm not going to hawk a book here to everyone, but this is called "This Religious Liberty in a Polarized Age," and it was out last year. And I will summarize the book and then some things in the book, and then talk about some implications for history and tradition. Angela said her presentation was in a way a letter to the Catholic bishops. This is sort of a letter to the justices on the court, particularly the strong protectors of free exercise. And some of this might find its way into briefs to them in the future. So that's kind of who it's aimed at. It's called "Can First Amendment History and Tradition Protect Both Sides in Polarized America?" So my book makes the following case. Religious freedom issues have often fueled today's polarization. But that's ironic because religious freedom has historically been and was meant to be a way to mitigate polarization. It protects people from suffering for their faith. That suffering tends to make people fearful, resentful, and leads them to retaliate. Such a cycle operated in Reformation-era Europe, especially in England. Americans adopted religious freedom in response to that dynamic, to avoid the suffering, and in Madison's words, avoid the torrents of blood that had been spilt in the old world. We've had a softer version of that cycle underway for several years in America. Traditionalists and progressives and the groups they support fear each other and take preemptive steps against each other based on that fear. Today, religious freedom can still mitigate the cycle of suffering, fear, and retaliation. At the least, it can avoid contributing to polarization, I hope, and argue. For that to happen, the protection has to be strong enough to reduce the suffering. And point number one has to be strong enough to reduce the suffering and fear. Number two, it has to be equal across faith. It can't be partial to Christians or other groups or whatever. And third, it does have to take account of other interests through both limits on religious freedom and through the protection of other rights. The combination of number one, strong religious freedom, and three, taking account of other interests means, of course, that the devil is in the details. But I argue throughout the book that careful analysis can protect the the important interests of both contending sides in the various contentions that we have. So I don't revisit the details of those reconciliations in this paper, although I'm happy to discuss them here. Protecting the important interests of both sides, in particular through non-discrimination rights plus meaningful exemptions, is the best hope to limit suffering, fear, and reprisal and serve the historic purposes of the religion clauses. So the Supreme Court has given appropriately strong protection to free exercise for multiple faiths. It has also protected important rights of LGBTQ Americans in Obergefell and Bostock. But the danger now is that it will retreat from protecting minority religions, non-believers, and LGBTQ people under the Establishment Clause and other provisions. Some recent decisions posing that danger have used the history and tradition approach that increasingly occupies the field from the Second Amendment and non-establishment to substantive due process. Now, I'm not criticizing a general attention to history and tradition. I believe it should play a role in disciplining the courts, especially with respect to unenumerated rights. But as a wide range of scholarship has shown, there are complications in defining the relevant propositions and traditions, historical propositions and traditions, and applying them to disputes now. So I use the terminology from Professors Blocker and Rubin in their Second Amendment work to focus on two complications that are particularly relevant in religion cases. One is the problem of anachronism, or alternatively, changed circumstances. In other words, applying historical analogies is difficult when, for example, in the Second Amendment context, the deadliness of guns has increased dramatically, or new laws address problems that were previously minimized, like domestic violence and whether somebody subject to a domestic violence order can possess a gun. The second problem is the problem of what they call the problem of violations. That is, traditions or founding era events that violate the core meaning of the provision in question. Classic example here is the Alien Sedition Acts, which, although very close in time to the First Amendment, are poor indicators of its meaning, even a lot of originalists would say. So both of these problems, the common answer to them is to adopt a higher level of generality in defining and applying historical meaning. Some specific traditions apply differently in new circumstances if you understand that there's a general principle behind it, or even more general tradition that is at stake. Or some specific traditions violate such broader principles. Those broader principles themselves might be anchored in history and tradition, but also in the basic logic and core purposes of a provision. So moving to a higher level of generality is a common answer. But of course, if you move to a higher level of generality, how high do you go? This paper does not try to resolve that problem in the religion clause, or let alone constitutional law generally. I make a few modest points focusing on the religion clause decisions that the court has issued. So first point is that as to strong protection for religious exercise that the court has given, which I argue is correct and crucial to serving the religion clause's purposes of reducing suffering, fear, and conflict. Nevertheless, it's also the case that the best arguments for strong protection rest on relatively flexible understandings of history and tradition, aiming to carry out a provision's historical purposes in modern circumstances. So, a couple examples of that, where the best defense of strong free exercise protection rests on using history flexibly. The first is the famous debate between Michael McConnell and Philip Hamburger over religious exemptions, which turns in part on whether clauses that were pervasive in state constitutions at the founding era that put limits on religious freedom to protect the peace and safety of society, whether those clauses indicate that exemptions were proper for laws that didn't rise to that level. Philip Hamburger quotes writers, including even religious freedom advocates, who said, "We don't seek exemption from any laws. We want to follow all the general laws." But there is an anachronism in Hamburger's reliance on those statements, an anachronism in Blocker and Rubin's terms, a changed circumstance in that overall legal regulation has grown substantially since 1789 to encompass many laws not in any direct, immediate sense serving peace and safety. And that's a perfectly understandable development in a modern, complex society, but it does mean that the application at that time, now versus at that time, may differ. So exemptions may best translate the general principle in modern times. Relatedly, history teaches the general lesson that exemptions serve the First Amendment's purposes. Colonies that disestablished churches and allowed dissenting religions soon enacted exemptions because free exercise without exemptions did not solve the problems that dissenting religions had. Requirements that were generally applicable, oaths or military service, would override Quaker conscience just as much as banning Quakers overrode their conscience. Exemptions are still needed today. Generally applicable laws without exemptions still cause people to suffer for their faith, and properly defined exemptions today can still reduce fear, resentment, and conflict. So the second free exercise example I give in the court's decisions involves Blocker and Rubin's violations category. That is, traditions that violate a constitutional provision's core principles. In the Espinoza case from 2020, the court held that states could not single out religious schools for exclusion from generally available benefits. The court refused to let the states rely on the 19th century state constitutional provisions, widespread provisions that forbade aid to religious schools. And the court disallowed that or rejected that tradition in significant part because it said those enactments were infected with anti-Catholic hostility. The court said these enactments hardly evince a tradition that should inform our understanding of the free exercise clause. In other words, even if you call that a tradition and it was there for a long time, followed well into the 20th century and sometimes reenacted in the 20th century, these enactments nevertheless, the court didn't follow them because they violated more foundational principles. So this is my paper's key point. Broad free exercise protection has rested on, and the strongest arguments for it rest on, a flexible use of history and tradition informed by the amendment's general purposes. If the court, now the second step then is if the court has done that for free exercise, it should also do it for non-establishment. So far, the court has used tradition to allow more room for official religious expression, but by its own method in free exercise cases, it shouldn't go much further with that. So let's unpack that a little bit. The court has in fact said that for the establishment clause, as it said for free exercise, that specific traditions are bounded and limited by more general foundational principles. The Town of Greece case that Angela referred to said that reliance on a history or a tradition, in that case legislative prayer, quote, must not be understood as permitting a practice that would amount to a constitutional violation if not for its historical foundation. And the court did go on to ask whether the council prayer practice was impermissibly sectarian or coercive. So in theory, Greece agrees with Espinoza that principles limit traditions. But, and here's the next point, the court has applied those principles in weak fashion. Town of Greece held that the prayers were sufficiently non-sectarian, even though over 15 years, all but 3 of the prayer givers were Christians. And even though the town could easily have changed that by expanding its outreach a bit. The court also applied non-coercion leniently, rejecting the arguments that citizens having business before a local council might feel pressure to join the opening prayer. Then Kennedy versus Bremerton, which we've discussed, read the record narrowly to hold that Coach Kennedy's post-game prayers did not pressure his players to join, ignoring the fact that his earlier post-game prayers, before he stopped doing it and then started, those post-game prayers had attracted his players, and that dynamic could easily recur. So lenient applications of non-discrimination and non-coercion rules like this contrast, or arguably contrast at least, with the court's stringency in applying those principles in free exercise cases. And that's a stringency in free exercise cases that, to reiterate, I think is quite justified. But the court should do it in both cases. The consistent principle is that stated by Congressman Daniel Carroll in the debates leading up to the First Amendment. The rights of conscience are in their nature of peculiar delicacy and will little bear the gentlest touch of governmental hand. So to be consistent, And to protect both sides meaningfully in today's conflicts, the court should not go further in approving official religious expressions. So as several papers here today discuss, Chip and Bob and others, the next big case may be the Louisiana Ten Commandment law requiring the Ten Commandments display in every public school classroom. The district court's opinion striking down that law, I think, approaches tradition in the ways I've advocated. It constrains any specific tradition of Ten Commandments displays by broader fundamental principles, non-discrimination among religions and non-coercion. And those principles are in turn drawn from and consistent with history, but they are more general and foundational. It reads those principles in a way that is sufficiently general, flexible, and vigorous enough to serve the First Amendment's historic purpose. For example, as I think Chip or Bob mentioned, talking about the cumulative impact of having the display in the classroom for students every single day for years. So the Supreme Court's decisions allowing official religious expression should not extend to the far more sensitive setting of a display seen by students daily in classrooms under a more flexible version of history and tradition that the court itself uses to protect free exercise rights strongly. That's my key point. Very last quick roundup, because I may be getting close to the time here. The conflict between religious freedom and other rights must also be addressed. Strong religious freedom alone cannot resolve the conflict between religious exercise and LGBTQ rights. It's a fact of life for now under Dobbs that the history and tradition approach for unenumerated privacy rights will be a narrow version that protects only rights that are deeply rooted, long-standing, and widespread at a specific level of definition and characterization. So, I mean, for present purposes, just the argument is simply that Obergefell should not be overruled under the key concepts of stare decisis that Dobbs accepted. Same-sex marriage does not involve the kind of harm to a life or potential life that Dobbs said made Roe versus Wade uniquely damaging. And entering into marriages under the authority of Obergefell involves specific concrete reliance that Dobbs acknowledged would support stare decisis. Now, overruling Obergefell would not have nearly as much of a negative effect as it would have had Congress not enacted the Respect for Marriage Act at the end of 2022, which requires states to recognize same-sex marriages entered into in other states. It's not perfect protection, but it is a sort of insurance policy against the overruling of Obergefell. But my final point to wrap it up here is that law would never have passed, and that kind of security for same-sex marriage rights would never have passed had there not been religious exemptions in it as well. It is possible to do both, and it's in a polarized society, it's necessary. Thanks.
Thanks, Tom. Next, we'll have Kathleen Brady.
Thanks, Micah. In 2022, the Supreme Court took a historical turn in its Establishment Clause jurisprudence. In its decision in Kennedy versus Bremerton School District, it announced that it was formally abandoning the Lemon test that had guided its decisions for over 50 years, as well as the related endorsement test. Actually, it had been clear for some time that neither of these tests commanded the support of a majority of justices, but as yet, the justices, or at least the majority of justices, hadn't coalesced around an alternative to replace them. Appeals to history and tradition appeared in majority decisions before, and more often in dissents, concurrences, and pluralities, but it wasn't until the decision in Kennedy that the court would embrace historical practices and traditions as a touchstone of its jurisprudence, at least for its cases regarding religious speech by the government. But the decision in Kennedy raised more questions than it answered. In the many dissenting, concurring, plurality, and majority opinions that had touched on history and tradition prior to Kennedy, the members of the court had in fact envisioned a range of different approaches. The various descriptions of the court's new historical approach in Kennedy used terms that echoed almost all of them. No more was needed in Kennedy than a gesture to the future, because the court found that the speech in that case was the non-coercive, private speech of a government employee and not government speech. But in the future, the court will have to grapple with what it means by its new focus on historical practices and understandings. It'll also have to decide how far to extend its new approach to other areas of Establishment Clause law that are now governed largely by principle or precedent, more or less historically defined. My paper focuses on government expression, and it explores what a historically based approach has looked like for the court's members over the years and where the court may be heading next. And I'll also make a proposal for where I believe the court should head that draws on the different possibilities that the court has considered. While the majority in Kennedy described the precedent it was abandoning as ahistorical, that was not, in fact, a fair description. The Lemon test had arisen from a particular type of historical analysis adopted by the court in Everson, which was the first case applying the Establishment Clause to the states. In Everson, the court examined the historical record to identify the historical purposes of the clause, and then it drew from these purposes a core principle of separation of church and state. While separationists on the court have made a similar type of argument over the years, there's nothing inherently separationist about it. Examination of founding era history could yield additional purposes and principles, and indeed the many long-standing historical practices that are inconsistent with strict separationism suggest that separation is not the only principle to glean from the historical record. Early dissents from the court's adoption of separationism made a very different type of historical argument. They observed that the court's decisions ran contrary to a wide range of deeply entrenched traditions, such as opening of daily congressional sessions with prayer, religious references in inaugural addresses, proclamations of days of prayer and thanksgiving, and many more. The argument here was not that these deeply entrenched practices are evidence of historical purposes, understandings, or intentions that the court had missed in Everson. The argument was that any interpretation of the Establishment Clause that's inconsistent with so many long-standing traditions must be wrong. Over the years, this type of argument was combined and then largely superseded by a slightly different argument that draws from long-standing practices information about the historical meaning of the constitutional text. In 1983, in Marsh versus Chambers, the court described the decision of the first Congress to appoint legislative chaplains as not only the beginning of an unbroken and deeply embedded tradition, but also evidence of how the Establishment Clause was understood at the time it was drafted and adopted. A little over a decade ago in Greece versus Galloway, the court echoed Marsh when it held that a town's practice of opening its board meetings with prayer fit within this tradition of legislative prayer. In a broader version of this argument, justices have drawn from multiple individual traditions like legislative prayer to see a larger pattern of government acknowledgement of the role of religion in American society that dates all the way back to the founding. For example, in 2019, a plurality of justices in American Legion versus American Humanist Association argued that the Bladensburg Cross War Memorial fit within that broader tradition. In both the narrow and the broader versions of this type of argument, justices are reasoning from long-standing practices to the historical understanding of the Establishment Clause. Unlike Everson, they're not looking comprehensively at the meaning of the clause, but they're backing into a partial understanding based on specific pieces of information about what was accepted at the founding era and then widely followed since that time. Yet another form of historical analysis has been proposed by Justice Thomas and sometimes embraced by others as well. Rather than backing into the original understanding of the Establishment Clause indirectly through the evidence of longstanding traditions, this approach would examine the historical record for the original meaning of the text more directly. According to Justice Thomas, the record reveals that the Establishment Clause was a federalism provision that resists incorporation, So then his focus becomes the original meaning of the term establishment. Each of these different forms of historical analysis has its own challenges and complications. Reasoning from the historical record to historical purposes, and then to interpretive principles that guide the development of doctrine has multiple steps, some involving considerable discretion. At its best, if the justice's understanding of the historical purposes of the clause is capacious enough, and constitutional doctrine can reflect a wide range of founding era insights about the relationship between government and religion. On the other hand, this approach is prone to the type of mistake made by the court in Everson when it drew just one predominant principle from a far more complicated history. At first glance, reasoning from long-standing practices to historical meaning would seem to be comparatively straightforward because it's essentially a matter of fit. In disputed cases, the job of the court is to decide whether a disputed practice fits within a pre-existing long-standing tradition, either a specific practice like legislative prayer or a more general tradition of religious acknowledgments. But the determination of fit will rarely be simple. So take, for example, the determination of whether a disputed practice fits within a specific long-standing tradition. The court has to select from the features of the tradition a set of essential characteristics. In short, it has to decide how to describe the tradition, even as its characteristics may be shifting over time. For example, when the court in Greece upheld prayer at a town board meeting, it described a historical tradition of non-coercive, solemnizing prayer that makes space for diverse faiths while avoiding entanglement in religious matters, as well as avoiding the exploitation of prayer to proselytize, advance, or denigrate particular beliefs. What the court saw in Greece was a tradition with features that reflect multiple familiar principles in an imperfect balance. When reasoning from specific practices to a broader tradition of religious acknowledgments, courts must decide how to describe the broader tradition, but also the role that specific practices play within that process of definition. Here, the court's plurality opinion in American Legion suggests an approach that may have significant appeal on the court going forward. The plurality began by making passing reference to a number of specific practices to illustrate the broader tradition of religious acknowledgments, but then it honed in on the practice of legislative prayer as an exemplar of the tradition. Legislative prayer, the court stated, stands out as an example of respect for differing views, an honest endeavor to be inclusive, as well as recognition of the important role that religion plays in the lives of many Americans. By choosing legislative prayer as an exemplar of values characteristic of the larger tradition of religious acknowledgments, the plurality in American Legion pointed the way to a form of historical analysis that is both tethered to particular historical practices, particular and general, but also flexibly guided by the principles that emerge from these practices. Over time, the identification of exemplars is likely to yield a set of principles that themselves do most of the work in disputed cases. An approach like this would share some of the features of the court's reasoning in Everson, but it would have advantages. The court would be applying principles, and this would allow it to evaluate practices both new and old in light of enduring values. But because its principles would be gleaned from long-standing historical practices, it would be harder to fall into the trap that Everson did when it drew a single dominant value from founding era history. Justice Thomas's suggestion that the court focus on the original meaning of the term establishment runs into a different problem. There was no single understanding of establishment or disestablishment in the founding era. On the one pole were strict separationists like Thomas Jefferson, and on the other were many Americans who favored continued tax support for religion as long as aid was generally available, at least to Christian denominations. And of course, there were people in between. But if there was no agreement on the meaning of establishment, there was agreement about a general set of principles. Founding era Americans understood and applied these principles differently, but almost everyone shared them, as well as the concerns and purposes that lay behind them. These principles included freedom of conscience, separation of church and state, religious equality, and a belief in the value of religious diversity. Another principle often received little attention because it was so widely assumed. Nearly all Americans, including strict separationists, envisioned a distinction between government actions that supported or advanced religion and those that merely reflected the important role that religion played in many of their lives and in the larger community. They differed on where to draw that line, but they didn't differ on the distinction itself. So inclusion, non-entanglement, respect for pluralism, non-coercion, and room for religious acknowledgments that don't cross the line into religious advancement or proselytizing. In short, all of the values recognized by the court in Greece were present in the founding era, and that is not surprising. By focusing on an early and long-standing tradition, the court found there the many principles shared by founding era Americans, and it found them in an imperfect balance as they've always been. If an examination of the original meaning of the Establishment Clause leads to the same principles that the court has found in the long-standing practice of legislative prayer, perhaps the role of the court should be to determine whether disputed practices align with these values. And as I just mentioned, this may be the direction the plurality was heading in American Legion. But there's a problem with such an approach. The values that America's long-standing practices and traditions disclose are in tension. They require balancing, often imperfect balancing. And if reviewing courts undertake to determine whether a disputed practice appropriately balances essential values, they'll be engaging in inquiries that often lack clear answers. But a slightly different approach avoids this problem. In this approach, the job of the courts is not to do the balancing themselves. This should remain the job of the political branches, who should have room to flexibly and creatively negotiate the demands of competing values in ways that are sensitive to different conditions and responsive to changing circumstances and concerns. The court's job should be to identify parameters and limits that place guardrails on these processes to protect minority voices and reduce the danger that fear, indifference, ignorance, or animus will deflect from good faith efforts to seek balanced solutions. Developed well, these parameters and limits will channel democratic decision-making to inclusive solutions that represent the full range of First Amendment values. And they will do so in part by involving those from many different backgrounds in these deliberations. In my paper, I propose a set of parameters and limits informed by the important but limited role of courts, the logic of the principles involved, and the lessons of our history balancing these principles. Because I don't have much time left, I'm not going to go through them in much detail, but I do just want to flag them. First, there should be a distinction between long-standing practices that have had a relatively static form over time, and others that are either ongoing dynamic traditions, readoptions of older practices that have been discontinued for a significant period of time, or new developments. Where a disputed practice is a relatively static tradition from the past, I agree with the plurality in American Legion that there should be a presumption of constitutionality, rebuttable in my view by evidence that the practice disparages minority faith, coerces conformity, or otherwise entails tangible civic disabilities or disadvantages. By contrast, where government officials are making current decisions about religious speech, more robust parameters and limits should apply. Religious expression by the government must be part of an effort to achieve one or more public purposes. So when government engages in religious speech, it cannot be to promote or advance religion. Governments must also take steps to make the public aware of their deliberations and invite participation by all members of the community. Inclusive outcomes also require good faith efforts to shape practices that embrace the full range of the community's faith traditions. Good faith means carefully considering feedback received and concerns raised. And where requests are made that are reasonable and easy to implement, they should be met unless there are alternatives that would also address the concerns of those who raise them. In addition, there must be an impartial, even if not perfect, non-discrimination policy where the practice allows for participation or representation by multiple faith traditions. Regardless, government's expression can't involve proselytization or the advancement or disparagement of particular religious traditions. Finally, government practices can't entangle government officials in theological questions, and they can't involve coercion, either in the form of direct legal penalties or civic disabilities or disadvantages. Where dissenters request to absent themselves from situations that are not coercive but involve prolonged exposure to material they find deeply disturbing, these requests should also be widely granted unless there's a compelling reason not to do so. There are obviously special concerns in the public school context, and I don't get into those in my paper. I want to close by acknowledging that religious expression in a polarized age is risky, and it's tempting to think that the best answer to the relationship between religion and government is strict separation. But strict separation misses opportunities to foster mutual understanding and respect, and it also has a track record of fueling rather than damping down divisions. Thank you.
Thanks, Professor Brady. Next, we have Stephen Smith.
Okay, thank you. So I circulated my paper to the main participants in the conference several weeks ago. And so I actually thought I might just sort of waive my time rather than bore people by reciting something that they had already read. But I didn't realize, and this has been a good thing, that there would be an audience, a fairly sizable audience of people who haven't had a chance to read it. So I will try and summarize the paper somewhat, but in an attempt to avoid boredom, a small attempt, I'll at least try and approach it in a little different way, I think. So I want to try and approach my paper from the standpoint of the title and the main theme of the conference, which is finding common ground. And I take it that is understood to mean, as Tom Berg has emphasized, in a polarized time. So I want to talk about, what common ground we have, what do we do when we don't have common ground, and then I'll try to use that to lead into what my argument or suggestion is. So what common ground do we have? I think we have common ground. I think nearly everyone could agree that as a textual matter, the text of the Constitution, or a historical matter, the American Republic has a commitment to religious freedom. I think that's a starting point I think most people could agree on. I think a second point would be not so solid a consensus, but some common ground that this is a good thing that we have a commitment to religious freedom. Now, certainly academics, Mike has done this, and I've sort of done it too, I think, raise questions about, is there a good justification for singling out religion for special constitutional protection? And it's surely true that not everybody thinks religious freedom is equally as important as other people do. Undoubtedly, there are Christian Hitchens types, who think that religion poisons everything, who probably wouldn't think that religious freedom is a particularly good thing. But nonetheless, I think it's generally true that Americans think that a commitment to religious freedom is a good thing. And you don't find very many people arguing for their positions by saying, yeah, that would promote religious freedom, which would be bad, and so forth. So I think there's some consensus there. I think there's also some consensus on some aspects of religious freedom, of what the content of religious freedom would be. On the free exercise side, nearly everybody, I think, would agree that, let's say, core legal coercion in matters of religion is not permissible. Prosecutions for heresy would not be permissible. An inquisition would not be permissible. And on the Establishment Clause side, there'd be sort of a general consensus, I think, that Congress or a state could not designate the Methodist Church as the church of the nation or the church of the state, subject to receiving support and financial governmental support and so forth. These areas of consensus may seem fairly narrow and minimal, and in a certain sense they are, but in another sense, I think we should appreciate that those are kind of significant achievements. Through much of history, those things would not have been, those propositions would not have been shared. And so insofar as they are shared now, that's something significant. Having said that, there's a whole lot of disagreement, of course, about the content of religious freedom and how to balance it against other interests and so forth. So how do we resolve those kinds of disagreements? So let me mention two or three things that I think we need to use, but are not really ways of coming up with satisfactory resolutions. One would be lawyers' arguments. when we have issues about religious freedom, we have to have lawyers' arguments. That's what we do, yeah, and so forth. We've heard a lot of that already today from Chip and Bob in particular, but from others as well. We have to do that. But I think we also understand by now that that doesn't produce it's not much of an answer to polarization or produce very satisfactory conclusions. First of all, we all know that on most issues, you'll have your lawyers with their briefs on one side and your lawyers and amicus briefs on the other side, and there'll be substantial arguments going both ways, and they're not really determinate in their results. Sometimes they are somewhat determinate, and I would agree, for example, with Bob and Chip, that probably under current law, Stone against Graham has not been overruled. So if a state says you have to post the 10 Commandments in every classroom, current law legal argument would probably say that's very problematic. But even then, there'll be a lot of disagreement about whether Stone against Graham, or at least the sort of jurisprudential regime in which it was grounded, is a proper one. And lawyers' arguments can't really, eliminate that sort of disagreement. Some will, of course, try to do this by saying, well, let's figure out what the original meaning was and let that determine. And I just think that in this area, it's clear that that will not provide very satisfying resolutions. And incidentally, not for the reason that that sort of approach often fails, but more for the reason that in this case, I think we can know pretty much what the First Amendment religion clauses were intended to do and what they meant to the people who adopted them. And what they meant basically was that these kinds of matters would be left to the states. They were like a deliberate attempt not to answer all the substantive questions of religious freedom that arise, and so they can't serve that function today. Another way to try and do this, very common today, Kathleen's talked about it, others have, so forth, is again, history and tradition, and that's something the court currently favors. And I think, again, that's necessary. It's just part of a country, and it's valuable that we do that. But I think, as other comments pointed out, Kathleen, I think also pointed out, history and tradition are rich, complex things subject to lots of different interpretations and not usually able to provide satisfying resolutions. Then a third thing is sort of the theory argument. We'll theorize about what religious freedom really means. I've written a lot about this in the past, and I won't elaborate on it to say that is, if anything, less successful than lawyers' arguments about actually generating some. And the basic problem, there are lots of problems with that, but the basic one is that religious freedom, I think, is not something with a Platonic essence that has a definite meaning. It can mean different things and so forth, and so forth. And so theory can't really tell us, what it means. So what to do? What the court and many others have tried to do, I think, in this situation, is to say, well, then let's just say that the Constitution means that government should be neutral toward religion, neutral among religions, neutral as between religion and non-religion. And again, I've written a lot about that and some in this paper. I think the upshot is the kind of neutrality that we sometimes announce or aspire to is basically spurious. And that becomes increasingly true, I think, in a polarized situation of cultural conflict and so forth, where the pretense of neutrality is just almost transparently almost fraudulent, I want to say. So what do we do then? And this is where we come to my paper. My suggestion is that we should recognize that for many of the questions that we argue about, there is no right answer. The Constitution means X or religious freedom means Y. And there's not going to be any uncontroversial answer. And so instead, I think we need to re-explore the strategy of jurisdictional diversity, which would mean within limits, we allow different states, different localities to interpret religious freedom differently, and they will, just as nations in the world. And historically, religious freedom has been interpreted in different ways. States will interpret it differently. We should make more room for that, I think, and so forth. So I try to support this proposal with quite a lot of history, suggesting that this was really the approach that followed the Wars of Religion and the Peace of Westphalia. It was basically a jurisdictional diversity approach. This was the approach that actually turned out to occur in the colonization of America. It was the approach that was adopted by the Constitution, once again, saying we're going to leave it to the states to decide this. And it was the approach that basically characterized our constitutional republic for essentially its first century and a half. So it has a long history, and that should be important actually to the court, although it hasn't been in a time when the court has been emphasizing a return to history and tradition. I try to make a normative argument for this as well. The normative argument, I think, is one that probably won't be very satisfying to almost anyone, because any of us who have our own particular views about what should be done, what kind of accommodation would be appropriate, and so forth, will find that jurisdictional diversity means that some jurisdictions will follow us and some won't, and so forth. But in a situation of polarization where there's not any real way to find common ground, once again, I think this is normatively attractive. Finally, I talk a lot in the paper about the cases that have been mentioned a number of times today, basically the private school, religious school funding cases of Trinity Lutheran, Espinoza, and Carson against Macon. That's already been discussed here, how in these cases the court has largely reversed the position that it had, say, 20, 30 years ago, in which, for the most part, it was always complicated and messy, but for the most part, if a state provided assistance to private education and included assistance to religious schools, that was likely to be struck down. The current view is almost the opposite of that. If the state provides assistance to private education and excludes religious schools that would otherwise be eligible, then that will be struck down as a violation of neutrality. These decisions have been heavily criticized. Thanks, Micah. They've been heavily criticized, usually on grounds that they've departed from the separation of church and state or whatever, from the previous regime. And I criticize them as well, but sort of from an opposite direction, you might say. So I'll just say quickly, I think that those decisions were right in saying that the separationist jurisprudence neutrality, so-called neutrality of the old decisions was not supported by the Constitution or required by the Constitution. They were wrong, I think, in saying that the sort of, let's call it the new neutrality, is commanded by the Constitution. I think that's not true. It's not commanded by the Constitution. I nonetheless argue that the results in these cases might be justified in a narrower way on the ground that the states who adopted such policies often did so on the assumption that they were constitutionally required to do so, and that was an error. They weren't constitutional. So just very quickly, in Maine, the Carson against Macon situation, Maine provided subsidies to students for attending private schools in districts where there wasn't any basically eligible public school. And originally they included religious schools in that program, but then they were told in about 1980 by the state attorney general that they had to exclude the religious schools because that was what the Constitution required, which was a reasonable interpretation of what the Supreme Court was saying at the time. So Maine amended the program so it no longer included them. That was a mistake. So I think Carson against Macon can be justified in saying we're correcting that constitutional mistake, but it would seem to follow also that if and when the mistake actually gets corrected, once it becomes understood that states are not constitutionally required to exclude religious schools, they ought to also have the option of adopting that view of what religious freedom means. That's a view that I think is not actually very attractive conceptually or historically, but it certainly is a respectable position, in the American history and tradition. It's one that lots of people have held. I don't think that we can say those people were all opposed to religious freedom and so forth. So that's a kind of flexibility that would be allowed if we had favored more jurisdictional diversity. Just to conclude, the risk here, as I've been told by various readers, is that moving to jurisdictional diversity today, that may be what we did for our first century and a half, but today it would promote greater balkanization, fragmentation in a time when, that's the last thing we need. And I think that's a real worry. But the hope is that it would allow there to be different regimes. People could, if they care enough about it, try to live in a place that's congenial to their views. And maybe this is Pollyanna-ish. We might actually even come to say, that there are different reasonable ways of interpreting what religious freedom means. We can respect people who hold to other interpretations than the ones we favor without having to say, that they're hostile to religion or they're hostile to religious freedom or they're hostile to this or that. We could come to understand that there are different visions of religious freedom that, again, within limits, could be allowed to flourish in different places. So that's the basic proposal of the paper. Thanks.
Thanks, Steve. We have time for questions, and thank you to our panelists for keeping on their schedules. I really appreciate that. So if you do have questions, you can put them into the Q&A. I think I can manage Q&A, also the chat, and otherwise you can raise your hand. But maybe I want to just start off while we're waiting for people to come in with a question for the panel. I think especially for Tom and Steve, because I think you read the histories somewhat differently in terms of the relevant principles of free exercise. So I sort of do just want to bring you into conversation about what you take the relevant principles to be, given that some states seem to have enacted restrictions over many years, and now the court has struck some of them down. So I can turn it back to Tom and ask how you think about a federalism principle or some kind of jurisdictional diversity principle.
So, I didn't send to Steve ahead of time as he talked about what balkanization would there be, and I mean, in any kind of jurisdictional diversity, but the key question is, what are the guardrails? What are the minimal limits? Because I think in times of polarization, the problem with polarization is significantly geographic and cultural, and so the charming differences between different parts of America have kind of turned into this sort of wall of uncomprehending and hostile two groups. And so you're like you without some policing by the courts, you're likely to get some extreme rules either way. I would say either way, and maybe we could argue about who's going to be more extreme and that sort of thing. So I guess, to me, that the devil is in the guardrails. And so that's what I would wonder. I mean, I argue in my paper that, the courts should play a role here, a significant role in trying to protect both sides. Now, that will not, and nothing that the courts do is going to make a huge difference in polarization, but they can make some difference. And it's not so much that they're going to come to some ruling that everyone agrees with, but if they make a significant effort to protect the contending sides under principles that are relatively consistent between the two sides, I think that holds out the best hope, or at least a better hope, probably, than very significant jurisdictional diversity. So, but that would be my question: what are the guardrails?
Yeah, well, that is obviously one of the really crucial questions here. You're right, and I keep saying within the paper, within limits, and I do have one section trying to say, okay, what would the limits be? And I tried to talk a little bit about what some of the limits would be. So, and I kind of mentioned this here right at the beginning of my remarks when I said, we all agree that you can't say the Methodist Church is the Church of the state of Texas or whatever, and you can't use core legal coercion and say, we're punishing somebody because of their religion. They're adhering to the wrong religion. Now, a lot of people might think, well, that's not sufficient. We need more than that, and maybe we would need more than that. But I'm not trying to specify exactly what the guardrails, as you say, would be, but they would be a lot less than what we have now. I think, at least that's the proposal. We would leave a lot more flexibility. So a lot of the questions, for example, that have come up today, like with Oklahoma charter school, or maybe even the Louisiana statute and so forth, I'd be inclined to say Louisiana may want to do one thing about this. Oklahoma may want to do something else. Massachusetts, New York, they'll probably do very different things, and that's okay. The thing that becomes very hard to predict, I think, is whether that will just lead us farther and farther apart, so that the polarization will increase, or whether it might be possible to come to respect different possibilities. And I will say that when we don't allow for that, people are almost forced to say this is the right conclusion, and those other people on the other side hate religion, or that or whatever, because they're just wrong, and they're violating the Constitution. And if we're a little more flexible, I think, and say, it's not that everybody hates religion or that they, whatever. They have different interpretations of how these values would fit together. Kathleen was quite eloquent about that point. There are lots of different ways in which these diverse principles and values can fit together. And within limits, we can respect that. Again, I'm not usually an optimist in these matters, so this is unnatural to me, but saying it's possible that we might actually achieve some kind of mutual respect and a little bit more of a live and let live type of thing. I think that did work somewhat historically, not perfectly, but somewhat, and maybe it could work again. Maybe it could work again now. What seems clear to me is that what we are doing and have done recently hasn't been working. So it seems to me like that's sort of worth a try.
Can I jump in for a second? And Steve, I try to be an optimist. I do. Very
I know you're much more of an optimist than I am.
But I'm going to throw some cold water on your optimism.
Oh darn! Okay.
Sorry about that. The one thing that I was sort of thinking about when I read your paper, and that, remember, my paper's on religious expression. It's not on funding or anything. I kept on thinking about the 19th century, right? Where these conflicts over religion in the schools, they actually reoccurred in all these different states. And so they shared these fundamental values, right? But they kept fighting. And it was almost like, instead of having one big fight, they had all these many fires all over the country. And so, when I was sort of thinking my idea through, one of the things that was going through my mind was, they even in the worst episodes, you could see the values, right? What would be a better way to kind of get people to, I guess use of course, good faith negotiation. I was just trying to work that in my mind. But in any event, so it's interesting because you fear balkanization, and I think that's a legitimate fear today. But in the 19th century, we just had many fires, right? And some of them were very, very bad. So anyway,
yeah, certainly. Yeah, you're talking about like the Philadelphia riots and all that sort of stuff. But so I'll just try to be quick because I know other people probably have questions. But I am in an optimistic and conciliatory mode today, So Kathleen, I want to say, I actually thought your paper and mine could sort of fit together in this way. I think someone reading your paper, I read your paper as kind of like a best practices, how to deal with this among people of good faith. How do we deal with some of these disagreements? And most of the counsel seemed kind of good, but I can imagine someone more skeptical might say, oh, right, you're just going to trust legislatures to, use all those best practices and have good faith and be inclusive, et cetera, et cetera. That's just naive. But if you combined it with something like a jurisdictional diversity approach, it might be, okay, we can respect, other things, and we won't all reach the same conclusions and so forth, but there's a little more room for us to try to employ some of those best practices. So my proposal is you and I could, in this
I thought about that, Steve. We did sort of, definitely there were synergies there in our papers, right?
So I've got a question from Chip, but he's going to ask it himself, I think. Do you want to unmute, Chip?
Yeah, yes, I do. It's a question for Tom. Tom, when you talked about situations where free exercise principles, maybe newly discovered ones, but free exercise principles could trump tainted traditions, right? You have traditions that are bad or weak or questionable or bigoted, and we're talking about funding of schools now, and that if that's the way we view them, and this is the way you were describing Espinoza and Carson versus Megan, that free exercise principles of non-discrimination ought to be superior to this tainted tradition. But the tradition of no state funding of religious institutions is not only from the middle of the 19th century, and it's not only about schools. It goes back to Virginia and the Bill for Religious Liberty, and it says no taxpayer should be compelled to help someone build a house of worship where they pay the salaries of ministers. That is to say, it was not focused on schools. It was focused on religious experience, in the sort of conventional, narrow, the way we think about religion as worship, not just as about education with some pieces of religious learning in it. So do you think those kinds of state restrictions on state funding that wasn't anti-Catholic? Virginia was not being anti-Catholic. The early states that had amendments like that were not being anti-Catholic. So I'm wondering whether you think at least that tradition of no state funding of religious experience understood that way should survive.
Yeah, I mean, they are two very different situations. The what Virginia and Madison said in 1789 was, or 1785 was, opposition to a tax that was specifically about religion and also for religious experience alone. So that's one distinction from the generally applicable funding. And the other it was that it was about clergy as opposed to being about education. Now they both involve religious experience, but the to deny funding to education because there is a religious component to it is basically a penalty on the choice of a religious education. We refuse to fund the education that you provide that has secular and civic value and is conceded to have that because you also integrate it with religion. Now, there are different ways to maybe try to separate out the religious component, have the funding be a little bit less. Maybe that's part of what you're talking about when you're saying, there's a problem with 100% funding for a religious charter school. But the two are really different situations historically and in terms of principles, because there are principles of fairness and equal treatment in education funding that weren't there in the 1785 Virginia thing. But my main point is not even really to argue that so much here, although I'm on record for years as supporting equal funding for religious schools, but to say that the court did that kind of analysis in Espinoza. It said these mid-19th century constitution, the Little Blaine amendments, violated these sort of fundamental principles, and therefore we're not going to follow that tradition. Now, they also said it's a tradition that started after the founding, so maybe it can't be an indicator of the founding. This gets into questions about whether you're an originalist or a traditionalist, and whether tradition can be any, post-founding history can be any evidence of the original meaning. So all of those complications, but for the most part, what the court did was it said this tradition, at least in part, is not to be followed because it's got these problems with the principles in it. And I do think that if that's an explanation of the best explanation of what Espinoza does, and therefore they ought to have a certain. And I'm really sort of aligned with Kathleen on this, that there's a complicated interplay between traditions and principles. I don't think you necessarily. It seems to kind of beg the question or assume the answer to say that the principles of non-coercion and non-sectarianism emerge from what we've done, because they're not. Legislative prayer was not always non-sectarian and so on. So I do think that when the court describes the tradition that way, it's reading the principles in as much as it is just looking at the tradition and saying, hey, isn't it cool that we've always been non-sectarian with this tradition? No, they're reading the principles into the tradition. But Chip, I just think there's a difference between those two situations, and the court says so as well.
Maybe a question that follows from this general discussion of history. Someone writes, this is an anonymous participant, asks, to the extent that history and tradition approaches make appeals to something beyond narrow historical practice, for example, to broader constitutional principles, don't they give up some of their claims to being more constraining on judges than other approaches? That's, I think, directed to all of you.
Well, I'll say something, I guess. I think the quick answer would be yes. But the hard problem, I think, is, you can imagine, okay, so people say, these are our principles, and they emerge out of our history and tradition. And then the court now says, well, we want to go back to history and tradition. And people criticize that by saying, quite, properly, accurately, you can't do anything with history and tradition. You can't really interpret history and tradition except if you have some sorts of principles, to guide your interpretation of them. Otherwise, you just have a whole bunch of narrow individual facts, a really nominalistic thing, and there would be no way to apply it to anything. So you sort of have to interpret it in the light of tradition. I guess I think, though, that it's still not meaningless to talk about history and tradition. It's something like when people like the court or Mark DiGirolamo, one of our friends, I think, is working on a book on this and so forth. There's still a sense in which I'm going to say, rather than just use the history and tradition as a source for a principle that then you just extract and run with it, so we're trying to keep it grounded, completely grounded in the tradition, and that will lead you to think a little bit differently, I think, than if you just went straight to principle. So there's a risk that tradition and history will just really the principle, and then we just have what we have already. But it's meaningful, I think, to say, even though you can't get away from principles, if you want to call them that, emphasizing history and tradition is still a meaningful thing to try to do, I think.
I agree with Steve. And I think actually it's made a huge difference doctrinally for the court to look at specific historical practices, because it's you started with something like Everson, right? And then you could, if you can't get to Everson if you're looking at particular historical practices, because they contain more inside them. And I don't really know, if the court, I don't think the court would likely eventually end up with a bunch of principles, right? But I think it's probably toggle back and forth for a while and kind of try to, just sort of kind of, figure what's out there. It's hard to know where it would go. But if you don't have principles, not only do you need principles to understand traditions, to decide what to see there. There's all sorts of, if you don't do that, how are you going to read those specific traditions? Tom, you mentioned a few of those problems, what level of generality, can you read it, the problem of anachronism. So there are no easy answers, whichever way you go.
If you look at what they did in Greece, that might give an example of how principles play a role, but then the fact that there's a long-standing tradition also affects it. One of the things that the majority says about, they had almost all Christian prayer givers, but they had taken, that's not because they chose Christians. They put it out. They invited anyone who was in any clergy in the phone book in the town of Greece, and that happened to be all Christians. And so then the question becomes, is that a sufficient effort at non-sectarianism or not? And the court partly justified its fairly lenient view of whether that was enough, because it said it was enough, by saying we don't want to adopt such a stringent standard of non-sectarianism that it makes it impossible to have the thing that has become a long-standing tradition, right? So the more long-standing the tradition and continuous, then maybe it's still bounded by principles, but the principles are applied less stringently when it, so I mean, there is that kind of back and forth. I mean, I think they could have in Greece done something pretty minimal, which was the record showed that there were synagogues and stuff right outside the town boundaries, and they could have made a bit of outreach. That was the point. But the interplay of tradition and principles, there are lots of different ways to do it. And every traditional scholar, including Mark, says that there are going to be instances where fundamental principles, disapprove of a tradition. That's his answer on Brown. We had there was definitely a long-standing tradition about segregation, but Brown overcame it.
If I could just say one other thing quickly, and maybe relate this again to Chip and Bob's presentation earlier. I guess I think that the backdrop for this recent emphasis on history and tradition goes something like this, that in the early 1960s, I would say, the court began adopting the view that the Constitution means secular neutrality. That was, I think, a position that would be very difficult to justify, either in terms of original meaning or in terms of our history and tradition up to that point. And someone like Mark DeWolf Howe, in his classic The Garden in the Wilderness, criticized the court, saying they're just extracting, a couple principles when the living practices of the American people tell us much more clearly what we mean about religion, what we think about religious than those principles. So the court recently, I think, is trying to say, on the one hand, that was a mistake. We're trying to get away from that. And that's one reason why just parsing the precedents and so forth, saying Stone against Graham hasn't been overruled, in some ways is, yeah, that's a good lauded argument, but not a very satisfactory response to the whole thing. On the other hand, my argues the court hasn't really quite grasped the point yet, because it's still just taking a different principle and applying it somewhat inflexibly to the situation. But I do think that's the background of some yearning to, can we get back to history and tradition, because we departed so far from that, I think, in modern jurisprudence.
I have another question from Angela Carmela, who asks this to Steve. Do you think we already have some jurisdictional diversity? For instance, states that pass their own RFRAs have strict scrutiny, others use Smith. When I looked at recent cases where Catholics seek exemptions, those are in blue states. Can you describe how your proposal could get us to a less polarized place?
Well, the first question, I think, yes, we definitely already have some. You can point to different ways in which we do allow for some jurisdictional diversity. Some's built into some of the doctrines, some's just in the incoherent application of them, and so forth. But yeah, we the court's left a good deal of room. On the other hand, I don't think very many people on the court or otherwise have appreciated the value of this sort of jurisdictional diversity. It's sort of a byproduct sometimes of certain doctrines, but it hasn't been. Micah's colleague, Rich Schrager, actually pointed me out to this, that he did write a great article in the Harvard Law Review like 20 years ago or something that did appreciate the value, but that's a very, very uncommon position, I think, So and so we do have some, in other words, but we could do a lot more to appreciate the value of this than we have done, I think, and would allow for more. As far as whether it'll lead to fragmentation or more mutual respect, once again, I think is one I just really don't know how to predict that, and it's very uncharacteristic of me to be optimistic. I'm not even optimistic. I'm just trying to be hopeful. And I think our current conditions make me less optimistic than I normally am inclined to be anyway, with the current condition of the country. But it's still a hope, you try to do what you can,
I've got one more question for Steve that I think I can sneak in before our time is up. And this is from Rick. He says, a challenge for the jurisdictional diversity approach seems to be the fact that for decades now, state courts unthinkingly constitutionalized as a matter of state law particular federal rules. Can that be unwound somehow?
There have been all sorts of, let's say, forces, factors that have led us to, I think, forget about or at least underappreciate our real tradition, our older tradition of historical, of jurisdictional diversity. And whether it can be unwound, I don't know. But I think what here you would sort of predict is that if the court began to allow for more jurisdictional diversity, some states would do different things than others would. I do think you'd have some states that would then start, allowing for different sorts of approaches to religious freedom, and others would adhere to the, let's say, the received jurisprudence of the last few decades, and that's fine. That's sort of what is contemplated by this, and it does seem to me that would be possible, in different states and different areas and so forth.
Okay, I think there's one last short question from Alan Brownstein, and this is also to Steve. Are you talking about state diversity or local, city, county jurisdictional diversity? He says for religious minorities, that can make a significant difference.
Yeah. Well, so I talk about primarily state diversity just because, not because that's the ideal form in which this sort of diversity would happen, but because that's sort of what we have. I think, we have different states and we have a system that respects a certain kind of federalism. But states are huge anyway, and there's a lot of disagreements within states and so forth. So I would hope, and I actually believe that this is probably true, that if you allowed for more flexibility among states, states themselves would probably, they differ in this, but many of them would allow for different localities to do different things. And that would be the ideal, I think, because once again, you're not going to say, the state of Massachusetts or the state of Alabama, they all believe X, there going to be differences there. And so the idea would be, it's kind of a subsidiarity ideal, allow these things to be done on the lowest level in which they can be effective. Yeah.
Can I just say one thing about diversity? There's a kind of diversity that we're overlooking here, and that is institutional diversity, right? Let different institutions go in different directions. One of my reactions to your paper, Steve, was that it's so focused on the Establishment Clause and how to interpret that. So what's going to be our position on public religion and that sort of thing? And yeah, those are very hard issues. The free exercise issues have become the most angst producing, at least for the conservative side. And if we thought about, like letting different institutions go different ways, that would probably support strong free exercise protection. And that might actually line up better with really allowing people to go in their different directions, even if they happen to live in the same geographic area, because the state adopting a policy means that people who are happen to be in that geographic area are stuck with that policy. Should that be the fundamental? Should that be the fundamental, or should the fundamental be kind of the institution or the community, non-geographic community with which you identify? Yeah.
Well, we're probably, so Tom, I'll just say real quickly, I think that comment is very much in accordance with, let's say, the logic and spirit of what I'm suggesting, and it would be not just, and I think that also, however, would have connections to discussions from this morning about application of various sorts of laws, like anti-discrimination laws that may not permit much institutional diversity and so forth. This would have implications for those debates as well, I think.
We have more questions, but no more time. So thank you to all of our panelists for this excellent discussion, and I think we will see you back at 3.